What is the process to contest a will? So the process will depend on what state you live in, and I'll just talk about New South Wales because that's where I live. In New South Wales, if you're going to make a claim, you have 12 months from the date of death to make that claim, which means you need to have started court proceedings by the 12-month mark from the date of death. If you miss that deadline and file your summons late, too bad, so sad, that's often the end of it. So you must check the time limits in your state. Now, if you've got some time before you hit that time limit, instead of filing the summons immediately in the court, what you might do is reach out to the estate and attempt to do a mediation before court proceedings start, or you might do written negotiations, send offers to each other before court proceedings even start. A lot of contesting wills matters resolve outside of court. So it is important, if you're considering making a claim, going to get legal advice early so your solicitor has time to do negotiations before any court proceedings start, because the real legal fees and expense really start to escalate quickly as soon as court proceedings are started, and it's in everyone's best interest to try to work it out without any court proceedings. If those early negotiations fail, or if you're really close to the time limit, you would then file your summons to commence court proceedings. I won't get into the nitty-gritty of what forms you need to file, but essentially you start the court proceedings and file your evidence. The estate files their evidence in defence, and the court will then send you off for a mediation. So the vast majority of matters settle at that point, because it simply is so expensive to keep going. However, in the event after you've started court proceedings, you've done a mediation, if the matter still hasn't resolved, the court will then set your matter down for a hearing, and the judge will order a timetable for any further evidence to be filed before that hearing. So yeah, there's certainly a lot of room for dispute resolution, mediation, negotiations. It's not like when you start proceedings, it's immediately listed for a hearing. The reality is once you start the court proceeding, it's probably going to be more than a year before you got to a hearing. Mediations generally happen within the first 12 weeks of starting the proceedings. So the court will send you off for mediation, regardless, even if you've done a mediation prior to court proceedings starting. Once you commence proceedings, the court will send you off for another mediation. So there is the potential that you're doing multiple mediations, and then you have to wait. If mediation doesn't work out, you then have to wait for the court to have time to hear your matter. And there is a real push to try to resolve the matter via mediation or alternate dispute methods before we get to a trial.